Okay, so the court received a request for ADA accommodations. This was after the court had advised you last week that you should get an attorney based on an affidavit and some statements that you made on this record that could implicate you for perjury and malicious prosecution claims, which are criminal actions. So the court has requested that you seek counsel, and my understanding is that you were not eligible for the public defender's office, but you've not hired an attorney. Is that correct?
Yes, Your Honor, I did apply for the public defender's office. I also appealed and they denied me, and then they called me and told me that even though I paid my own rent and paid the rent for my son, who was a senior at Michigan State, and I only received disability benefits from the Veteran Affairs Office, I think it was just barely, I didn't qualify, and I called.
That is an incredibly precarious situation. The combination of the judge's warnings, the denial of a public defender, and the defendant now standing unrepresented creates a substantial risk. The stakes could not be higher.
Probably about 15 different defense attorneys, and I couldn't afford any of them.
Okay, so with that being stated, you don't intend to hire an attorney. You intend to represent yourself or your own interest, even in the statements that you represented to the court.
Yes, Your Honor.
Okay, and you understand that there's a risk of putting yourself into a situation where you could be facing perjury charges.
Yes, Your Honor.
Okay. The court wants to also address your request for ADA accommodations. You said based on a panic PTSD symptom management. You're requesting permission to take breaks as needed if panic or dissociative symptoms escalate. By nature of how we run the court, if there's a situation where you need to take a break, the court always grants breaks. So that's not something that needs to be requested or specially implemented. You request ability to pause testimony briefly for grounding before answering questions. I don't know what that means.
The defendant requested breaks for panic and PTSD symptoms, but the judge clarified that breaks are standard procedure for anyone in court. A subsequent request for grounding before testimony was met with confusion by the judge, highlighting the divergence between the defendant's perceived needs and the court's standard practices.
Yeah, it just means that sometimes I have to calm down. I'm on Klonopin medication for PTSD.
Okay, we don't rush you, so that you don't need to request that. So you can breathe or take your time whenever you are getting ready to answer a question.
Okay, Your Honor.
Okay. Access to water at all times. Water is available. Did you bring water?
No, I did not.
Okay, so how do you think you're gonna have access to all times? If you think I'm gonna get you the water?
AP Pfeiffer said I would have it
That we can get you what we give the jury. It's a very small bottle of water, but you're more than welcome to bring all the water that you need. If your ADA requires you to have access to water, I would have imagined you would have brought water with you.
That was just part of a request in case, how long it takes.
We can get you water, but this is the size of the bottle. Okay? So if you need any more water than that, it's best that you bring a water bottle. That's why I have this one. Okay. Permission to remain seated. You will be seated at all times during your testimony and under oath. It says questions to be asked one at a time. For the rules of evidence, they can't ask compound questions. So you don't need to make a request for that because they're not allowed to ask compound questions. If there was a compound question, there would be an objection probably by somebody. No yelling, raised voices, or hostile or intimidating tone directed at me. I don't know what you mean.
What I mean by that, Your Honor, is I felt that AP Pfeiffer had that type of tone with me at the last conference, and my son had to watch on YouTube when the conference was over, where AP Pfeiffer called me crazy, and I have post-traumatic stress disorder, and that definitely put me over the edge. Your son had to watch, you said?
No, my son, he watched it. He watched because he knows your hearings are on YouTube, and he watched it. And then I didn't want to watch it because I've already been in, mental health crisis for a couple of months now. And I felt it was very unprofessional and against ADA.
That sounds like a highly charged and increasingly tense situation. The clash between practical needs, like ADA requirements, and the strict formality of the courtroom, combined with the concerns about tone, really sets the stage for significant conflict moving forward.
What does ADA law prohibit someone from yelling or raising their voice?
Calling someone crazy at the post-traumatic stress disorder.
I don't recall in my proceedings, Mr. Pfeiffer or anyone calling you crazy. That's number one. Number two, your request you're saying these are ADA requests. Asking for no yelling, raised voices, hostile or intimidating tone in a courtroom. First of all, some of it's relative, and what's intimidating to one person is not what's intimidating to another. What is I could be considered yelling right now, but I have to be assertive and I got to make sure my voice carries. And I also give instruction to anybody who testifies here to make sure their voice carries. And I've heard Mr. Pfeiffer give curative instructions to people that I want you to speak like you're talking to the person way over there. And so you're not going to be able to control either of their tone or the volume of anyone's voice when they're asking you a question. That's not an ADA requirement. It's not protected under ADA either. Okay? You're asking for court intervention if question becomes adversarial, aggressive, or re-traumatizing. I don't know what is traumatizing to you or re-traumatizing.
That passage paints a vivid picture of the tension and clashing perspectives in a courtroom. It highlights the inherent difficulties of subjective interpretation versus legal standards and the uncompromising nature of adversarial proceedings.
The court will not put themselves in a position where they have to figure out what might be traumatizing you. My job is to make sure that they follow the court rules. If there's questions that are argumentative, that's against the court rules, or if there's an objection, then that's when the court will intervene by the nature of a violation of the court rules. But when it comes to just asking questions that you don't like, you still have to answer them. You understand that?
Yeah.
Ability to request clarification of questions, you absolutely can request. I usually give that instruction when I swear a witness is in. If you don't understand the question, just ask for clarification. And sometimes it could be that they just need to rephrase the way it was stated. Prohibition on threats of criminal exposure. Absolutely not. You must be advised that you could face, some criminal exposure by some of the things, especially under your circumstances. And never have I seen anyone so adamant that they want to produce documents to the court directly and on the record that could put them at risk for criminal exposure. And that's what we have here, which is why you were advised that you should get an attorney.
Yeah, Your Honor, the clerk was the one that told me that I have to serve that, right? So.
The clerk cannot tell you that you need to serve anything. You probably called the clerk to find out how to get something to the judge. Mm-hmm. So that was on you. You can't blame it now on the clerk that you sent an affidavit admitting to perjury.
Okay, I don't believe I was admitting to perjury, but I understand.
Okay. And then let's see. You asked for acknowledgement on the record that I am a witness with PTSD. I don't know how you expect that to be acknowledged. You're only allowed to answer the questions that are asked. And so if that's asked of you, that's fine, to the extent that it may or may not be relevant to the information being brought forth, but the court won't be making any acknowledgments that on the record. And you're talking to me, and I already have been advised that you have PTSD. So
yeah,
I'm the only one.
PTSD and panic disorder.
Yeah, so that's fine. You let the court know. I'm the only one making a decision in this matter. This is not a jury trial, so you don't need to make an acknowledgement to anyone other than me, and I've already been advised. Okay. Assurance that accommodations will not be used to assess credibility. That's not an ADA protection none of these things that you're talking about are ADA protections.
I was given the list from
who?
Sorry.
Who gave you this list?
From one of the officials that I talked to.
What's the official's name?
I'm not sure. I don't have it with me right now.
Okay, these are not ADA requirements.
Okay.
These are some things that you might like, but in this particular situation, I'm the one that assesses credibility. Okay. No one else is assessing credibility, just me. Okay. No negative inference drawn from emotional responses, pauses, or needs for breaks. I don't know what that means. If you're talking about how we determine credibility, there's a lot of mechanisms used to determine credibility. You won't be able to control that. Okay?
I guess I should have rephrased that better. I just would ask Your Honor to take in consideration that I've been in an active mental health crisis for a few months now since my father passed away and everything else I'm dealing with.
I can imagine, and to the extent that you need, some pauses or that you need a break or that you're emotional, the court does not typically just make a negative inference from that, other than the fact that you are emotional.
Yes, ma'am.
So let's see. Ability to submit brief written clarification if testimony is interrupted by symptoms. You are not allowed to submit written communication or clarification of testimony. Testimony is done here in court verbally and on the record. That's why I asked what official gave you this information, because we need to contact them, because this is not information that should be disseminated to people.
Your Honor, I'm a plaintiff in several civil cases right now, so the rules are a lot different. I've never been.
Rules are a lot different than what?
Where I can submit things, say things. So I'm just not familiar with the criminal court.
Do you know that I do civil matters as well?
No, I did not.
Yeah, we do civil and criminal here, so I'm very familiar with the civil rules. So that's why I'm asking you, what about this makes you think that this is appropriate, and even in civil court?
To have ADA accommodation?
These are not ADA accommodations.
Can you just repeat the question? I'm sorry.
These are yours. I asked for the person who gave you this list because we need to ensure that this is not being disseminated for people to believe that these are reasonable requests. There's civil or criminal. Your testimony is on the record under oath, in person, not in writing.
Okay, I understand.
Scheduling and environment. Testimony scheduled earlier in the day when possible. The testimony will take place whenever the court's able to get it taken.
It was a list, I'm sorry. Those weren't all just my...
Limitation on the length of continuous testimony. We will not limit the testimony. You ask the questions. Sometimes cross-examines and direct examinations take longer than others. I have no control. I don't know what their questions are. I don't know anything about the evidence. And now we have a bond violation, so that could take even longer. I can't limit that. The only thing I can do is give you breaks as needed.
Thank you.
Let's see. Quiet area away from the opposing parties. You're looking for a quiet area away from the defendant.
No, that was on the list.
Okay, permission to leave promptly after testimony concludes. So once you're finished with your testimony, I usually ask the attorneys if you're free to be excused. They'll let me know if you can be excused or not, okay? If you're not able to be excused, there may be a circumstance where we'll put you in a private room.
Thank you.
And then you're asking for confirmation that ADA accommodations will be implemented and enforced to the extent that you needed ADA accommodations in the court. The hearing aid, ability to, get your mobile device in here. Some of those things, then we would make sure that happened. These things that I have here are not ADA accommodation or requests that are protected by ADA, I should say.
Okay.
Assurance that the requesting accommodations will not result in retaliation or prejudice. I'm the only one making the determination here. I'm taking the time to go through these one by one so that you are clear. Whoever gave you this list should have been clear that these are things that you can maybe request, but they're not protected under ADA.
That's right.
And then accommodations to be memorialized on the record, which we've done. And so did you have any questions about this?
No, I would just request that if you have time, to review the January 2nd conference where I was attending, and where everyone had left the room, and it was just you and Assistant Attorney Pfeiffer in the courtroom, and that is where you could see it on YouTube where he called me crazy.
Okay, I will review whatever is that you're requesting me to review. Again, you're not looking to hire an attorney to represent you?
I tried to, and I just couldn't afford when I was denied public defender.
Okay, my other concern is that that believe there was some level of request that you were asking to retract something that's out of the court record. You don't have the ability to retract anything that you filed with the court.
Okay.
Okay, so that will be, whatever you filed with the court will remain as part of the court file.
I was just told that by Attorney Pfeiffer that no one could accept it except the detective, so the detective has it.
I'm not sure what you're referencing.
He said that he could not accept any affidavits or clarifications, and the defense attorney cannot, and the judge cannot. So he said that I have to submit it through Detective Kennedy.
Right, correct. So you can be in contact with Detective Kennedy. I don't know if she's here today or not. But that's your best bet, is to be in contact with her and provide her with any information.
I did.
Okay, very good. And so if you don't have any other questions, I'm going to let you go back down to sit, because I believe we need to address the timeline here for the exam, because I don't believe that the exam can go today because the detective is still working on the evidence, correct?
Yes, there's one other, again, nuts and bolts issue for the record, because one of the emails from Ms. Crawford said that she was advised that she did not need an attorney. I just want to make a clear record that it wasn't the public defender's office who advised you of that, right?
That certainly paints a complex and uncertain picture, with the judge emphasizing the finality of filed statements and the defendant's limited options for clarification, all while the status of today's exam remains completely up in the air.
They didn't say you don't need an attorney, correct?
No.
Okay, perfect.
Who advised you that you did not need an attorney, ma'am?
Pretty much every attorney that I called that was too expensive, they said that witnesses, you normally do not require an attorney unless there's a charge.
That's valid that they would say that, unless you told them about the affidavit you sent before.
Yeah, I told them everything. They just said that they don't even accept clients unless they have a charge.
They don't accept clients unless they have a charge?
Unless there's a charge. Most of them didn't even know what a conflict attorney was when I asked them.
It must not be criminal attorneys.
They were.
It doesn't make sense. I have a criminal attorney sitting right there. Are you familiar with the conflict counsel?
Yes.
Because you are a conflict counsel often, aren't you?
Yes.
Can you represent me then? Because I've asked everybody I could.
And so, I don't know if you've been calling criminal. The conflict counsel is quite common.
I have.
And then there's a lot of times your witnesses have to have an attorney to protect them from, saying something on the record or even questions that could, be self-incriminating.
Mm-hmm.
You understand your right against self-incrimination.
Yes, I tried. I called a lot of them, and most of them wanted $5,000 to $10,000 down just for 1 hour.
That sounds accurate.
Yeah.
For a retainer, but
I have a son that goes to Michigan State, and I have my own bills, so I have no way to afford it.
I can imagine. I recognize that you're strapped, but the court has done with the best that they can do. I can't make the public defender take the case,
right?
And I can't make you get an attorney. That I can only give you an opportunity to do that, to protect yourself.
Okay.
So we're going to have to move forward with this case. Either way, let me get you can go have a seat, though. Thank you, ma'am.
That's a tough situation, highlighting the serious challenges some defendants face in the legal system, especially when it comes to legal representation. The emphasis on the defendant's choice, despite the inherent dangers, is a critical point.